Thank you, Mr. Njai.
The good thing with the adjournment is that we've now received the authorities bundle, the statutes bundle, and printed as of argument. I could hand those up.
Yeah, sure, thanks.
It's the papers bundle, isn't it? That we know.
No, it's
Oh, sorry.
The authorities, it's the statutes, and it's the heads of argument.
Okay.
Thank you. Makes things easier.
We are told that the resources are hard to come by at the Department of Justice.
Let's leave it there. What is it?
It's the pleadings.
And elections. Yeah,
Can I say it?
sure.
Mr. Mukaitodi, we didn't have the pleadings bundle this morning.
No, you didn't.
It looks like we now have.
Yes. That's what we handed up before
Oh,
that.
thank
Before
you.
tea, ne?
Yes, before that.
Thank you.
Thank you, Mr. Njai. To be made proceed.
Thank you, my lord.
Still some more to come.
Yes, that should be authorities, statutes, and heads of argument. My lord, where the debate right now is there are three topics I will address, and my learned friend will address the bias point. Hopefully, I can finish all of this in 45 minutes. The first is whether or not the Electoral Commission had the power to uphold the objection. The second argument, and there are two in relation to this. The one is, well, is Mr. Zuma disqualified by virtue of Section 47? And there are two strands to that argument. One strand is the conviction strand. The second strand is the sentence strand. So let me deal with the first topic then, which is, does the Electoral Commission have the power to uphold the objection? We say that the Electoral Commission has the power directly drawn from the Electoral Act, and the power directly drawn from the Constitution to make a determination as to the objection and to apply Section 47 as part and parcel of the determination as to that objection. To start then with the statute, your lordships and your ladyships and the learned professors would have the statutes bundle, and the first is the Electoral Act. And we ask that you start off with Section 27, which is at page 16. And Section 27 regulates the submission of lists of candidates. And what it says in Section 27, subsection 2, subsection B, is that the list or lists must be accompanied by a prescribed, and that's prescribed in the regulation, I'll come back to it in a minute, by a prescribed declaration signed by the duly authorized representative of the party that each candidate on the list is qualified to stand for election in terms of the Constitution or national or provincial legislation under Chapter 7 of the Constitution and has signed the prescribed acceptance of nomination. Now, where that you will that prescribed form, it's prescribed in the regulation, and you will find that at page 81 of the statutes bundle. It is Appendix 3. And if you turn over the page to page 82, you will see that when a form is submitted with a list of candidates under Section 27, subsection 2B, it must be submitted together with that declaration. And if you look at item 2 of that declaration, I declare that I have confirmed that each candidate on the list is qualified to stand for election in terms of Section 47 and or Section 106 of the Constitution of South Africa, or national or provincial legislation, or any applicable legislation. So the statute, together with the regulations, directly import Section 47 into the frame of the statute. So that's the first step. You go to the IEC with your list, and you have to make, by regulation, this declaration, the declaration that invites the IEC to consider your application through the application of Section 47. Now, once that has happened, the list is then placed under Section 29 for inspection in a public place through the Government Gazette. And after that, there is then an opportunity to object, and that is Section 30. And so, in Section 30, subsection 1, it says any person, including the Chief Electoral Officer, may object to the nomination of a candidate on the following grounds. A, the candidate is not qualified to stand in the election. So we know at page 82 that a declaration has been made that the candidate is qualified to stand in the election in terms of Section 47 of the Constitution. So the objection is responding to that declaration. If the candidate is not qualified, there is an objection that says the candidate is not qualified. That can be submitted under Section 30, subsection 1, subsection A. But once that has happened, so the IEC now has a copy of the objection, and it has a copy of the declaration. It is comparing the two. It then goes to Section 30, subsection 2, and that's about service. Service is no longer an issue here. Then the Commission itself is then duty-bound by Section 30, subsection 3. The Commission must decide the objection. And the objection could be based on 31A, not qualified to stand, particularly in the light of the declaration that the candidate is qualified to stand under Section 47 of the Constitution. So under Section 30, subsection 3, it says the Commission must decide the objection and must notify the objector and the registered party that nominated the candidate of the decision in the prescribed manner by not later than the relevant date stated in the election timetable. So here we find that it's clear that under Section 27, Section 30, and the regulations, the Electoral Commission has the power to decide the objection based on Section 47 of the Constitution. We also find a source of this power in Section 47, subsection 2 of the Constitution. Now, if you go to that section, firstly, subsection 1 deals with the excluded categories. And then subsection 2 says a person who is not eligible to be a member of the National Assembly in terms of subsection 1A or B may be a candidate for the Assembly subject to any limits or conditions established by national legislation. So what you see here is that A and B, those do not have any reference to the conduct of an individual. It's simply a membership of a body, whether you are National Council of Provinces or whether or not you had been performing another job. So you may stand in the election, but the people that may not stand in the election, that are excluded by Section 47, subsection 2, are those in C, D, and E. An unrehabilitated insolvent, a person declared to be of an unsound mind, and a person who has been convicted of an offense and sentenced to more than 12 months. So that's the second source of it. So it's making it clear that the distinction you had about that there is a difference between standing in an election and being elected in the National Assembly actually is not recognized in the Constitution. It's one chain, and it starts with the Electoral Commission, which then screens the candidates who may then participate in the election. So that's the second textual source. Then we also make a purposive argument. If the argument we make was not accepted. It would make it impossible to administer Section 47(1), because the consequences of the argument made on behalf of Mr. Zuma is that people that are not qualified to be in the National Assembly must nevertheless be in the National Assembly and sit in that first meeting that Mr. Mbofu was talking about. And now he says in that meeting it will be chaired by the Chief Justice. But what happens in that meeting is that there is an election of a speaker who takes over the role of chairperson. So what you may not have is people who are not qualified, nevertheless making a determination of the election of the speaker. Those people that are excluded by C, D, and E. And so that would produce an absurdity. It's not helpful to say under Rule 13, the meeting is chaired by the Chief Justice, because that meeting has a specific purpose. It is to elect the Speaker and the President. Well, it's the Speaker, the Deputy Speaker, and the President. But it is a meeting of those persons who qualify to be members of the National Assembly. Now, it is true that other people will lose their status as the National Assembly runs. You may be an unrehabilitated insolvent 2 years after you assumed your position, but then the National Assembly will deal with that. So there is no argument here about the exclusive power of the Electoral Commission. The argument is a narrow argument, which is the Commission has the power to uphold objections based on Section 47 of the Constitution. The fact that at a certain stage, a person may lose eligibility, that obviously will be dealt with by the National Assembly. But at the electoral stage, the screening is done by the Electoral Commission. So we say then that you should dismiss the first ground of appeal. It has no merit whatsoever. We then go to the second ground of appeal, which is the issue about conviction. Now,
I just want to warn you that your 10 minutes is up now. You may expect questions from the members of the bench.
Indeed.
But proceed.
So we then go to the second issue, which is the issue of the conviction. Now, what we know here is that under Section 47, subsection 1, subsection E, the text of the Constitution says anyone who, after the Section 2 is convicted of an offense. We will deal with sentence in a moment, but let's stick now to convicted of an offense. We had the argument. The way we understand the argument is that if you have not been convicted following a criminal trial, which has Section 35 rights, you are not convicted for the purposes of Section 47(1)(e). Well, we say that the argument is plainly absurd. A contempt of court, and we've referred to a number of these judgments. Perhaps I should, yes, in the Faki judgment, which now what happened is that I've lost my own bundle of authorities. But let me do this. So the Faki judgment is at page 14. So in the Faki judgment at paragraph 6, 10, and 12, and in the authorities bundle, you'll find the Faki judgment from page 14. So at paragraph 6, 10, and 12, so those paragraphs you will find from page 18 and 19. So that's where Justice Cameron analyzes the contempt of court, and he says that it is a crime. In fact, in paragraph 6, he says, it is a crime unlawfully and intentionally to disobey a court order. This type of contempt of court is part of a broader offense, which can take many forms, but the essence of which lies in violating the dignity, repute, and authority of the court. So it's quite clear there that it's described as a crime. You also find that at paragraph 10 of that judgment, page 19, and you also find it at paragraph 12. which is also at page 19. So it's described as a crime, as an offense. In fact, the same position applies in the PECO judgment of the Constitutional Court. So that you will find at page 127 of the authorities bundle, 127 to 148, and particularly at paragraphs 28, 30, and 31. And in all of those paragraphs, contempt is referred to as a crime or as an offense. Even in the Zuma case...
Excuse me, Mr. Mugaituri, please may I have the paragraphs again?
Yes, it's paragraph 28, 30, and 31 of PECO. And PECO you will find at page 127 to 148 of the authorities bundle. So contempt there is described as an offense or as a crime. Now, even in the Zuma contempt case, which is also included in the bundle of authorities, but it's also part and parcel of the application itself. And I'll show your leaderships. So the judgment is at page 263 of the bundle of authorities. So you will find again there contempt of court at paragraph 61, 66, 93, 61, 66, and 93. It's described as a crime and as an offense. Described as a crime as an offense. And so it's clear in our law that if you look at the first requirement for section 47(1)(e), which is the offense part, right? Is contempt of court an offense. It's clear that it's an offense, it is a crime. Then you are left with, well, convicted. So people are only convicted of crimes. They are not convicted of anything else. They are convicted of crimes. The procedure for the conviction has no bearing on whether they have been convicted or not. What we know for contempt is that the procedure is hybrid. And we know in the judgment of Justice Kampempe in the Zuma contempt case, that what she said was that it is a hybrid. It's part criminal, part civil. But that's the process. But the substance of it, when there has been a declaration that you are guilty of the crime, that is a conviction. It's as simple as that. You find this in another judgment also, which we have cited, which is the Meadow Glen judgment. And you will find the Meadow Glen judgment in our bundle of authorities. It's item 8, it's page 87. And when you look at paragraph 16 of Meadow Glen, it's clear that they talk about a conviction for contempt of court. And that's the Supreme Court of Appeal judgment, which you will find at page 87 of the bundle of authorities.
Paragraph 16, you said?
Paragraph 16 of Meadow Glen, yes. Paragraph 16 of Meadow Glen. And it's at page 87. That's where it starts. You are looking for paragraph 16. So we now know that for contempt, you are convicted. Contempt is an offense, contempt is a crime. In this particular case, Justice Modiba was raising this point. We only have to look at paragraph 142 of the judgment of the Constitutional Court. And that's paragraph 142 where the order appears. So that you will find at page 297 of the authorities bundle. And so after all of the analysis, the paragraph 3, subparagraph 3 of paragraph 142 says, it is declared that Mr. Jacob Gedehlegisa Zuma is guilty of the crime of contempt. So there is a clear declaration that he is guilty of the crime of contempt. So it could have said he is found guilty of the crime of contempt, but that is a conviction. There can be no debate about that. It is a conviction. It is irrelevant that that conviction came through the civil process. That is how contempts are litigated. What is relevant is that contempt is a crime, and Mr. Zuma has been found guilty of that crime. So when we go back then to section 47(1)(e), we look at those words, convicted of an offense. So we only have to answer there. Was this an offense? The answer to that is yes. Was there a guilty finding in relation to that offense? The answer to that is yes. So we are dealing with someone who is a convict, convicted of an offense. The next question then, so that should be the full answer to the conviction complaint. It is a conviction complaint, but the conviction complaint has no bearing whatsoever. Now, it is true that that is not appealable. That is what the Constitutional Court found. And it knew that it was not appealable. Mr. Zuma argued there at the Constitutional Court that it was unfair to convict him for contempt when he had no right of appeal, but the Constitutional Court decided against it. So here we say it is not open to this court to revisit. I heard Mr. Mbofu saying he is not revisiting, but in substance, when you listen to him, he is revisiting. Because he even said that it was an unconstitutional finding. He even said that, these words, unconstitutional finding. Now, what would be unconstitutional is for the Electoral Court to depart from the judgment of the Constitutional Court.
Sorry, Mr. Ngaito, but that judgment did not specifically deal with 47(e), in particular regarding the aspect of whether that sentence conviction could be appealed or not. What's your take on that?
Yes, it did not have to deal with it. It only had to deal with whether or not, in the presence of the Constitutional Court, he had a right of appeal. Because you must remember what happened. Mr. Zuma was guilty of contempt of an order of the Constitutional Court. So it's only that court that could address his contempt.
But
Yeah,
Mr. Ngogo,
sorry.
but do you accept that under normal circumstances, a conviction which follows on the contempt of court proceedings, that conviction would be appealable?
Yes, I accept that. It's
But
clear on the law.
it's because of the situation in that particular case, peculiar situation, that the court that convicted him was the
Yes,
apex court.
precisely. Right.
And then he had no
No, but he did
court to go
complain.
to, yeah.
He did complain before the Constitutional Court.
Yes.
There is a full analysis of that judgment. He did complain, and that issue was dealt with and resolved. It's not as if it's being dealt with for the first time here. The issue about his right of appeal was a subject matter of debate.
But now within the context of section 47(1)(e), doesn't that have the effect, don't you, well, what does that do to section 40? Let me put my question this way. What does that do to section 47(1)(e)? Because section 47(1)(e) does refer to an appeal. In other words, a conviction must be a conviction which has been subject to an appeal, a sentence that has been subject to an appeal, and the appeal was dismissed or the appeal was upheld and the sentence was reduced.
Yes, but we know. Sorry.
Yes. Go ahead. That's fine.
No, we know here that that issue of whether or not he had a right of appeal was debated, found against Mr. Zuma.
Yes.
We also know that he, in fact, attempted to rescind, also raising the very issue of the appeal. And even on that rescission, that was dismissed. Now we come back to section 47(1)(e). It's simple the way it applies. Of course, if there is an appeal, we must look at whether or not, and you remember that if you look at the section 47(1)(e), what it says is that you have to take into account the appeal. So go back to the actual words. Anyone who, after the section took effect, is convicted of an offense and sentenced to more than 12 months imprisonment without the option of a fine, either in the Republic or outside the Republic, if the conduct constituting the offense would have been an offense in the Republic. But no one may be regarded as having been sentenced until an appeal against the conviction or sentence has been determined, or until the time for an appeal has expired. So what it simply does, it simply allows the period of a conviction for a person who has been convicted to appeal it. But it even says, or the time for that appeal has expired. It's clear that where there is no appeal as a matter of law, that period will not be applicable. So it applies where there is an appeal, it applies where there is no appeal. But where the Constitutional Court has decided in this sentence, in this conviction, there will be no appeal. That provision, what all it does is, we are not going to implement it now because we're going to wait for your appeal. But there is no reason to wait for the appeal when the Constitutional Court says we are the final court and there's no appeal.
But is it a proper way of interpreting a statute where you interpret it according to what had happened in a particular case?
No.
Because, I mean, obviously people need to know where they stand in relation to the application of Section 147. They can't decide their case on the basis, well, in this situation, this is how the section must be interpreted. But if this situation applies, it must be interpreted differently. Surely that's not the correct way of interpreting the statute.
No, but my lord, what we submit here is that if you took the view that the judgment of the Constitutional Court on contempt does not apply, so Section 47(1)(e) does not apply to it because there is no appeal. If you did that, you would in fact be rewriting the Constitution, which is actually a worse position to be in. What we are asking the court to do is to give effect to the words of the section. It's clear that where there is an appeal, the section does not come into operation because you have to wait for that appeal period to either be brought or to lapse. But in circumstances where the highest court has made a determination and it has considered that appeal, the section still applies. The section is never excluded because the only way to get to that conclusion is by arguing that Section 47(1)(e) is excluded in the case of contempt of court criminal findings by the Constitution. That we say is untenable.
Mr. Mukaitobi, would you say that this provision deals with several scenarios?
Yes.
Right? Yes. So the first scenario is that a person is sentenced, right? Which is the scenario here. There was a sentence imposed. Following the imposition of a sentence, two things could happen. An appeal could be lodged,
Yes.
right? Which is essentially a petition
Yes.
by the convicted person
Yes.
seeking either a reduction or complete setting us or an interference with the sentence that has been imposed,
Yes.
right? But then there could be a third scenario where it's uncertain. There's uncertainty regarding what's going to happen because the window for appealing is still open, right? That's why the proviso further reads until the time for an appeal has expired. So it deals with several scenarios. But given what has happened there, that there are no prospects of a further appeal, these scenarios are simply not applicable. They're irrelevant.
Yes. No, I would submit, my lady, that it's clear that in this particular case, the section applies. The section does not apply simply because the imposition of the sentence.
No, I'm with you. I'm putting it differently.
Okay, yeah.
I'm saying it's dealing with scenarios that are irrelevant given the facts here.
Yes, to the facts.
Because he couldn't appeal.
Yes.
So the fact that there was no appeal to be determined.
Yes.
That's the second scenario. There was no, he had been sentenced.
Yes.
That's first scenario. Second scenario is that an appeal had to be determined if it was pending.
Yes.
But that's inapplicable because he couldn't appeal
Yes.
further.
And
The third scenario is that the period for appealing must not have expired. But that scenario also is irrelevant here because he simply could not appeal.
Yeah. And my lady, to add this, and I've said this to the court already, the appeal was debated. They fully debated at the Constitutional Court. It was debated.
But even if it was not, just on a simple interpretation of the effect of the sentence imposed by the Constitutional Court, it's the ultimate sentence,
Yes.
right? At this point, I'm not dealing with the intervention by the President.
Yeah, no, I'll deal with that.
We're simply dealing with the sentence
Conviction.
as imposed
Yeah.
by that court, yeah.
No, indeed.
Sorry, Mr. Nguga, my sister on my left has got a question for you.
It's fine, Mr. Mugatobi. I think.
Thank you, my lady, for actually pronouncing the full
Oh,
sentence.
sorry. I'm sorry. Yeah.
No, it's fine. We've passed that point, and I don't want to take us back. You can proceed.
Okay.
Or the point you had a question on.
Yeah.
All right,
Sure,
thank you. All right, so I think we can leave the point at Justice Modiba's summary. So where we are right now is under Section 47(1)(e), he has been convicted of an offense. The fact that there is no appeal is irrelevant. The section cannot be written out of the Constitution simply because there was no appeal. What that leaves us then is the sentence part. Now, the way we understand the argument to be is that the sentence that Mr. Zuma was actually imposed with was 3 months because there was the remission of sentence. Now, the problem with why that is wrong is actually the premise. Now, I just want to go back to how Mr. Mpofu raised this. So his argument, the way he frames the argument, is to say, well, in order for us to look at this issue of the sentence, is we must look at the ultimate sentence. He calls it the ultimate sentence. He says Section 47(1)(e) is about the ultimate sentence. And he says the reason why it is about the ultimate sentence is because of that appeal provision. So that's why it becomes secular. But that is not the case. Section 47(1)(e) is about the sentence that has been imposed by a court. If it is overturned by a court, so be it. The distinction is that it must be imposed by a judge. The president has no power to impose a sentence. Let's go back to the section. Anyone who, after the section took effect, is convicted of an offense and sentenced to more than 12 months in prison. So that's the first issue. When you look at the sentence imposed by the judges at the Constitutional Court, was that a sentence of more than 12 months imprisonment or not? We must not conflate this with these two judgments. I've actually read these judgments, Smith and Sheffield. We must not conflate this with the period actually served, the date of release, which is what the remission did. The remission never changed the sentence. It never said you are no longer sentenced to 15 months. You are now sentenced to 3 months. It simply determined the period of the release. And the executive is entitled to do that. The executive cannot say the courts did not say you are sentenced to 15 months. The executive can say, we are forgiving you, and therefore you are released, you can go home. And this is the central problem with the argument, which is based on the so-called ultimate sentence. The ultimate sentence is true, but only partially true. It's true only if the matter will be dealt with by the Supreme Court of Appeal or by the Constitutional Court, because it is the Supreme Court of Appeal and the Constitutional Court that have the ultimate power to sentence. And that is what the section is about. The fact that the president says, I don't want to keep, I think it was this case of Musheho, I don't want to keep sick people in prison, or I don't want to keep old people in prison, because I have the power to do so under Section 84 of the Constitution. In other words, the power to forgive, I've got that power. Does not mean that you can now go back and rewrite the sentence imposed. When you look at Section 47(1)(e), that section is about what was the sentence imposed by the court. That's textual. But purposively as well, it works. Why do we have Section 47(1)(e) of the Constitution? Why? The reason we have it is because it is a legislative determination that certain convictions and certain offenses would preclude a person from exercising their rights to come to Parliament. And the reason why they put it at 12 months is because it is a signal of the seriousness, not only of the conviction, but of the offense. And the reason they also make it clear that there should be no option of a fine, it's because what the constitutional drafters are trying to tell us is that serious law breakers should not be lawmakers. That's the purpose behind section 47(1)(e) of the Constitution. Once you take an executive decision by the president, and you use that executive decision by the president to change, because the argument is as crude as that. It says, just change it from 12 months to 3 months, when there is in fact not even a decision by the president to change it from 12 months to 3 months. The president is simply saying, get out of prison, because the prisons are too full. But the sentence that the section 47(1)(e) focuses on is, did the judges think this was a serious enough offense to take you to prison without a fine for more than 12 months? Once the judges have made that determination, then you are precluded by section 47(1)(e) from becoming a lawmaker, because you are a serious and a serial lawbreaker. And we have to confront this problem and not try to tiptoe and make excuses for this particular appellant. So we say that, number one, the president has no power to change a sentence. He did not even purport to change the sentence. What he did do, he did not say Mr. Zuma is no longer sentenced to 15 months, but is sentenced to 3 months. He has the power to affect the period of release, now that's the period actually served. And you will see this clearly from these cases of Smith and Busheko that have been referred to usefully by our learned friends. It's about releasing them. We say that, number two, you are also going to interfere with the purpose behind section 47(1)(e), which is people in Mr. Zuma's position should not be in parliament. It's as simple as that.
So Mr. Ngugaito, I just want to make sure that I follow you correctly.
Yes.
As a result of a remission,
As a result
of a remission,
Yes.
of a sentence, where do we stand now? What is it? Does the remainder of the 15-year period still stands? Or has the release affected that?
He clearly has been released, but that has nothing to do with section 47(1)(e). He clearly has been released. That is, this court is not dealing with the remission. This court is dealing with what does section 47(1)(e) apply to. And that is where there's confusion. We end up talking about the implications of the remission, but it's a completely irrelevant topic to what this court has to apply. This court has to answer the question, did the Electoral Commission correctly apply section 47(1)(e) or not? The only portion of section 47(1)(e) that applies to this debate, because we've closed the conviction debate to this debate, is what was the sentence imposed by the judges? And once the answer to that question is, well, the judges imposed 15 months, you ask another question, did they give the option of a fine? Well, the answer to that is no, they didn't. The fact that the president came along and decided to forgive not just Mr. Zuma, many other prisoners, is irrelevant to the question of what sentence was imposed by the judges.
And your answer is that the sentence 15 years still stands?
No, the sentence...
Sorry, 15 months.
No, the sentence that was imposed by the judges for purpose of section 47(1)(e) applies, because that's what you have to apply your mind to. You are not sitting here as another correctional services board. What you're sitting here as is the electoral court to determine the question of eligibility. It's already prescribed in the Constitution.
Mr. Ngugaito,
Yes, sir.
let's look at the purpose of a sentence.
Purpose of a sentence.
Yes, the purpose of a sentence that is imposed by the court upon conviction.
Yes.
Retribution, it's punishment,
Yes.
it's prevention.
Yes.
Right. So you are saying he is eligible to...
It's not eligible.
He's no longer... Sorry,
so
didn't... So he's disqualified.
He's disqualified, yes.
From
Yes.
National Assembly membership
Yes.
because a sentence of 12 months,
More than 12
months
Yes.
without the option of a fine
Was imposed by the court.
imposed, right? And then the president exercising his powers in terms of section 84(1)(j decides, no, the court had said you will be, you are sentenced to 15 months, right? But then he decides that no, you will not spend.
Yeah, not serve. Yeah.
You will not serve 15 months.
Yes.
You will only serve 3.
Well, I mean, that's also another problem. He never actually made that decision. It's
Yeah,
just
the effect.
a calculation.
The calculation that had to be made.
Yeah.
So he only served, because of the remission, he only served 3 months. The sentence that was imposed by the Constitutional Court, you are saying that determines
Yeah.
whether he's hit by
It starts
Section
47.
47. But doesn't that section become academic? Because I want to, let's draw a distinction between a parole, right? A person who's paroled, and a person whose sentence is remitted. So if a person is released on parole, that person effectively is not free. You see, Mr. Zuma was paroled on medical grounds, right? So if the remission did not happen and he remained out of prison on the basis of the medical parole, he would remain an imprisoned. He would remain a person who's under the authority of the corrections department,
No, I accept
because he's still under punishment.
Yes.
You know, he's still sentenced,
Yes.
right? But what happened after he was remitted is completely different. The corrections department no longer had any authority over him because he was no longer under punishment. He was no longer a sentenced person. That sentence had simply fallen away.
That is what we argue against. We say to the court that the Section 47(1)(e) focuses on the sentence that was imposed by the judges, because it is the judges that, through their sentencing, reflect on the seriousness of the conduct of the prisoner. The fact that the president comes at a later stage to exercise his own powers to release a prisoner, to decide, for instance, people should not be jailed during COVID, which is what Smith and Kwasha want. That fact does not affect the sentence that Section 47(1)(e) focuses, because it says convicted and sentenced. What was Mr. Zuma convicted for? A crime. What was the sentence for? A crime. Was the sentence for 12 months? Yes. Option of a fine? No. So that section operates 47(1)(e). It is not disabled from its operation by a subsequent act of the executive. If you did that, we say you would ultimately undermine the purpose behind Section 47(1)(e). And we have posited the purpose behind the Section 41(e), which stands in contrast with what my learned friend tries to argue, because my learned friend's framing of the case is Section 19 of the Constitution. But Section 19 of the Section 47 is also in the Constitution. So Section 19 applies to those persons who are not disqualified. And once you are disqualified, you cannot say that I have a Section 19 right, because that means you are making the Constitution internally contradictory. And that is what I'm afraid will happen if you upheld the argument that somehow the Constitutional Court determination became illusory. It evaporated. It never evaporated. It still remains. That was the sentence imposed, and that is why it's excluded.
But doesn't the remission of the sentence render the order of the Constitutional Court academic?
No, we say no, it doesn't, because if you are to ask yourself, for purposes of Section 47(1)(e), what was the sentence of the Constitutional Court? What is the answer to that question? We say the answer to that question is clear. It is never rendered academic by a mere act of the president to forgive people that are in prison. It's an impossible legal position.
Well,
So
sorry, go ahead.
So your admission advocating Mugatobi,
My admission.
your submission is that the remission does not affect the original sentence imposed by the court.
When you are dealing with Section 47(1)(e), because Section 47(1)(e), that's why we say you've got to keep your eyes on the ball, because that section is about what was the sentence imposed.
Okay. So remission is not about the expunging.
No,
the
it's not.
record.
It's not about, because there was never any sentence imposed by the president. There was only one sentence. It was imposed by the Constitutional Court. And we say when you actually read that together with the purpose behind Section 47(1)(e), it makes total sense, because it's about the legislative choice that certain people that the judges have decided are serious offenders should not hold political office.
When he addressed us, Mr. Mpofu submitted that effectively Section 47 limits the rights in Section 19.
Yes.
Okay, wait.
Sorry, madam.
That was his submission, and he reminded us that when there's any provision that clashes with the rights that are set out in the Constitution, an interpretation that promotes entrenched rights has to be preferred.
No, madam,
I'd like you to respond to that.
No, it's a fundamentally misguided proposition. The Constitution cannot be in contradiction with which is the other, right? The provisions of the Constitution should be given effect harmoniously and simultaneously. A Section 36 limitation applies to a law of general application. It doesn't apply to the Constitution itself. So the section we are dealing with here is a section in the Constitution. In other words, Section 19 applies to people who are not disqualified. And if they are disqualified by the Constitution itself, they don't have Section 19 rights. It's actually a fundamentally misguided proposition that is actually bankrupt on constitutional jurisprudence, because it presupposes that you can have a scenario in which one section of the Constitution limits another section of the Constitution. There is no such thing. The two sections in the Constitution have to be read harmoniously together. The old Constitutional Court judgment of 2002, UDM, makes this very same point, that you cannot have two clauses in the Constitution conflicting with each other.
Please give me the year again.
It's 2002, it's the United Democratic Movement. That was the case of whether or not individuals who joined political parties could switch political parties midstream. And there were clauses in the Constitution that were cited, I think, for the rule of law conflicting with the freedom of political choice and political rights of political parties. And the Constitutional Court, in a unanimous judgment, says it is a legal nonsense that one section of the Constitution can limit another section of the Constitution. The two stand to be given effect harmoniously and simultaneously. And the only way to do that here is that Section 19 applies to those that are not excluded. Those that are excluded do not have the rights, because it's the same Constitution that says you are excluded if you are in this category. So I'm afraid it's actually a fundamentally misguided proposition.
Well, Mr. Nwako, let me see if I understand your argument. The argument is essentially is based on the separation of power, and it is as follows.
Yes.
Judges and courts convict people and impose sentences on convicted persons. And it's only judges and courts that can change the conviction and sentence. The executive doesn't have power to change the conviction and sentence.
Well, I mean, you could theoretically, I mean, there are instances where the president just says, from now on, I will not regard you as, well, they cannot change the fact that you're convicted.
I can see that you know where I'm trying to get at. Yeah. Proceed.
So now, what they can never do, I mean, think about, for instance, the case of McBride.
Yes.
Where there is a defamation case where someone says, you've defamed me because you called me a murderer. The Constitutional Court says you can never change the fact. You see, you can decide that I am actually going to forgive, but the fact that there was a conviction, the fact that there was an imposition of the sentence can never be changed. The only way that can ever be changed legally is by another judge. So what the executive does never changes the fact of the conviction. It never changes the fact of the sentence that was imposed. What section 47(1)(e) is about is asking this prior question. What was the sentence, what was the conviction? Was it for an offense? And what was the sentence? Was it 12 months or more?
Sorry, but that argument, Mr. Ngwaitobe, doesn't undermine the purpose of Section 84 of the Constitution, which grants the President powers to remit sentences.
Not at all.
Because I think that
Sorry, madam.
there must be a harmonious way to read Section 47 and the powers that are vested in the President to pardon, to remit sentences. So we can't just read them in isolation.
No,
there must be a way.
We accept that entirely,
Yes.
but what we submit to the court, it's clear that it's an important part of the argument. We accept that the Section 47 and Section 84 must be read harmoniously. Section 84 is not undermined by an argument that Mr. Zuma is excluded by operation of the Constitution. Why? Because the purpose of the Section 84 was so that he could be released from prison. He was, in fact, released from prison. The consequence was that, as a matter of fact, he served 3 months and not the 15 months that the Constitutional Court said they should serve. But the question is, as a fact, what sentence was imposed by the Constitutional Court? And that
But hang on, Mr. Ngwaitobe, that argument seems to put form above substance, because in substance, when a remission is granted, that has got an effect on the ultimate, well, let me not use Mr. Mpofu's phrase, but that has got an effect at the end of the day on the sentence which a person served.
Yes, on the, no, I accept that.
Yes.
It has an effect on the period that you serve. It has no effect on what sentence was imposed. And Section 47(1)(e) is about that question, because it is about our own society view on, which is collectively expressed through the Constitution. It is about the view of the Constitution about whether or not certain people in certain categories should be allowed to stand in public office. That does not infringe on any right whatsoever, because it's a qualification criteria. Before you can have the right, you must be qualified.
Okay, I hear you.
Mr. Ngwaitobe, had the President pardoned Mr. Zuma and not simply remitted his sentence, would it make any difference to this argument? Would he still be a convicted person because the court said so?
That's excellent. This is really an excellent question, because it sharpens the focus of the debate. Because if I'm right in my submission, which is that Section 47(1)(e) is about the judicial determination of conviction and sentence, it doesn't matter. Take, for instance, the case of McBride. The Constitutional Court makes it absolutely clear. The fact that you were convicted and sentenced never changes. And if the Constitution in Section 47(1)(e) is about that fact, it applies to Mr. Zuma with a pardon. It applies to Mr. Zuma with a remission of sentence. It applies to him with a parole. So the problem we have here is that we are conflating concepts that belong in different species of the law. If we are dealing with constitutional law and who is qualified to stand for it or not, the Constitution answers that question. Now we cannot convert that and change it so that we can accommodate Mr. Zuma. He is one of those people that are precluded by the Constitution. That fact will never change. Thank you, Madam. My learned friend will speak on the bias point. I just wanted to check here if there's anything. Oh yes, there's one more point to the question Justice Duba you have raised, which is, what is then the benefit, the constitutional benefit, not general benefit. What is then the benefit of the remission? It's actually here as well, which is at Section 47(1)(e). Look at the last sentence of that section. A disqualification under this paragraph ends 5 years after the sentence has been completed, which means we're dealing with two different things. One is the sentence that was imposed, but the second one is the sentence that was served. So he will benefit from it. 5 years from the 3 months that he served in prison. So it is not as if that pardon or remission never has a constitutional benefit. It has a constitutional benefit in the sense that at 5 years after he has finished being in prison, physically being in prison, you calculate 5 years from there, then he is qualified. Right now, he is not qualified either under the first part of section 147(1)(e) or the last sentence, which is the lifting of the disqualification. The lifting of the disqualification is about the actual condition, but that first imposition is about the judicial act of conviction and imposing a sentence. So and that framing of the Constitution is actually perfectly consistent with the rest of the Constitution. And it has nothing to do with Section 84, because he will one day benefit from that, but it's premature now. He's not qualified now to be a candidate. It's as simple as that. He's not qualified today to be a candidate. Thank you, Justices. Could I ask for permission to leave if there are no other questions directed at the arguments I have made?
So, sorry, before you conclude, I just want to sum up your point that you make in relation to the last sentence in section 47(1)(e). So you are saying, since the court imposed a sentence of 15 months, that imposition is what this court should work with, not the effect of the remission.
Yes.
And he will only qualify for National Assembly membership in terms of section 47(1), 5 years after that sentence has been completed.
Yes, which now means because
So wait.
Yes.
And my question to you is, when was the sentence completed? Because remember, and I invited you to explore the purpose of a sentence, right? And that consideration becomes relevant in determining when was the sentence completed.
So that's why I say that once you look at the last sentence to section 47(1)(e), it's completed. When you look at the first line, it's convicted and sentenced.
Yes.
So it's clear here that the intention is to focus on the actual period served. So if he leaves prison, it's the period served, which is you go to Smith, you go to Mokoshi, and then 5 years from that period, because we cannot say, well, he has completed it when he is in fact out of prison. So we submit that there is a possibility, if you look at that, to say the period was in fact completed when he left prison physically. But what you can never change is what was the sentence that was imposed on him.
So what sentence was completed, Mr. Mukaitobi? What is the sentence that was completed? Because we're trying to determine the date.
Yes.
What is the sentence that was completed?
Mr. Zuma, first, he did not complete his sentence. We know that as a fact. So he never completed his sentence.
Why?
Because he was released initially on medical parole, which was declared unconstitutional, and secondly, he was released as part and parcel of the special remission. So he never completed the sentence.
But isn't the effect of the remission that when he reported back to Escort
Yes.
prison, and he was met with the news that the president has remitted his sentence. What that meant is that he had completed serving his sentence.
Well,
Right? So that's the date. He had completed serving his sentence, why must we ignore the period that he served? Because that was the sentence. The period he served is the sentence.
No, my lady, that is just incorrect as a matter of fact and as a matter of law. The period that was imposed on Mr. Zuma is 15 months. It is not 3 months. The fact that he subsequently serves, and we're not asking this court to further punish Mr. Zuma, we're simply asking the court to make a declaration that the IEC was right when it found that he was excluded by virtue of Section 47.
Okay, please answer this simple question. The last sentence reads, a disqualification under this paragraph ends 5 years after the sentence has been completed.
Yes.
In this scenario, in this case, what is that date?
What we know here on this fact is that Mr. Zuma, as a fact, was released from prison.
Yeah.
So, which means whatever the courts decided would be the correct sentence, which is the first part of the section, was interrupted by presidential decision. So, which meant that he left prison. But that is irrelevant to the point I'm making to the court, which is Section 47(1)(e), current position that Mr. Zuma was excluded because the judges had imposed a 15-month sentence. You cannot change that by simply saying that the president effectively imposed a different sentence.
No,
Sorry,
please
sorry,
answer
sorry.
very.
Different question.
Sorry, I'm still.
Yeah.
Please answer. Okay. Answer a very simple question. If the IEC is faced with this question, if the IEC has to determine when does this 5-year period that is referred to in Section 47(1)(e),
Yes.
when is that date? What's the answer?
Well, there are two answers to that
Yeah.
question. The first question is, it would be the 5 years calculated from the judgment of the Constitutional Court. And that is also a viable answer to it. So that's one. The second one is, it is the sentence actually served. And if
This section talks about completing a sentence. We're still in the 5 years. On your argument, we're still in the 5-year period, right? Is the sentence completed or not? On the present facts, is the sentence completed or not?
No,
You're saying it's not completed.
No, we know as a fact that Mr. Zuma received a remission, which meant that he had to leave prison. And so, if the correct construction of complete means physically leave prison, we know that that happened already after 3 months after he was in prison.
Physically and lawfully.
Well, this is a big debate about the lawful part, Justice.
Sorry, Justice Yacob.
No, because-
yes.
Sorry.
Sorry,
One
I
at a
just
time.
wanna.
One at a
Yes.
time,
Can I
please.
just?
One
I
at
don't
a
want to
time, please.
lose this point. I'm still waiting for that date. We're still in the 5-year period. Are you saying he's still serving a sentence?
No.
Are you saying the sentence is not completed?
Well,
When was it completed?
Justice Wadiba, I think we're dealing with two different
Yes.
propositions.
Yes.
Let me try and get to where we are.
Yes.
Firstly, for purpose of Section 47(1)(e),
Yeah.
my argument is simple. My argument is the section focuses on the date of the sentence that was imposed by the Constitutional Court.
Yes.
And from that premise, the sentence is 15 months, therefore he is disqualified. So we can put a full stop on that.
Yeah.
Now there is another theoretical possibility, which is when would the 5 years come into operation? Now to that I propose two answers. One answer is that 5 years would be the period actually served, which means it will be 5 years from the 3 months. That's one answer to the question. And so there's no inconsistency there between that and the first submission. The second one is, it is theoretically possible that the sentence that was imposed by the Constitutional Court, that the 5 years is calculated from there, that has nothing to do with whether or not Mr. Zuma...
It's calculated from when?
From the sentence imposed by the Constitutional Court. That has nothing to do with whether or not
No,
Mr. Zuma...
I'm not with you. You are saying it's calculated from the sentence. I'm
From the lapse
looking
of
for a
the
date.
sentence.
From the lapse of the
End
sentence.
or completion of the sentence.
So you calculate 15 months from the date of the imposition.
Not 15 months. Oh yes, 15 months from the date of imposition, yes. I was thinking about 5 years.
I'm trying to understand your submission.
So you're giving us 2 dates,
Yeah,
right?
so those
So
are
it runs from the day he walked, or it runs from the day
yes.
he would have completed serving the 15
Yes,
months.
so I say proposition 1 is 5 years calculated from the lapse of the 3 months.
The lapse of the 3 months or the lapse of the 15 months?
Of the 15 months. Now, those are the 2 propositions. Now, out of those propositions, we have to work out, firstly, what is their relationship with Section 47(1)(e) and whether or not Mr. Zuma is currently eligible to stand. I say it has no relationship whatsoever. The second is, as a matter of sentencing law, what is the effect of that remission? The effect of that remission, we would say, obviously, has resulted in Mr. Zuma not serving any period. So that was the effect of it. It was that he would not serve the remainder of the period. But it was never to mean that a judge would not regard the finding and the sentence as not having been found and sentenced as per Section 47(1)(e).
So you are saying we shouldn't be too concerned about the fact that he only served 3 months
Yes.
in prison. What we should be concerned with is that the highest court in this land
Yes.
found his conduct so serious
Yes.
that a sentence of 15 months imprisonment is appropriate. And because that sentence was imposed, he's then hit by the disqualification
Yeah.
in Section 47(1).
Indeed,
Is that-
and thank you for that summary, Madam. I was just trying to find the actual section. But that, in fact...
Sorry, Mr. Nguga, there's something that sort of bothers me here. I've just listened to the interaction between you and my sister regarding the construction of the last sentence in Section 47(1)(e). Now, you've already told us that the disqualification ends 5 years after the sentence has been completed.
Yes.
But now we know for a fact that the sentence which Mr. Zuma completed was the 3-month sentence. Is that not so?
No, this is the point I was trying to
for all
make.
intents and purposes, Mr. Zuma.
No, Justice.
Because on your construction, Mr. Zuma will never be able to qualify, to complete. That disqualification will never end, because there is no sentence which he completed. You understand
Justice.
my problem here?
No.
Yeah.
Then maybe I am wrong because
No.
I've expressed...
You're not wrong.
Because maybe then I'm wrong in the way I've expressed myself.
Okay. Express yourself.
Let me correct you.
Yes.
So you start off with 15 months.
Yes.
That's the sentence imposed.
Yes.
Now, that sentence could be completed when Mr. Zuma actually completes 15 months. Correct? That's one. There's no problem with that. That sentence, which is 15 months, can also be completed in a period that is shorter than 15 months. For instance, by a remission. It's still completed because he is out of prison. It's still completed. For instance, by a remission or by another form, which could be an expungement, but it's still completed. In other words, he cannot go back to jail to serve the period. So it's not inconsistency to say you've got a period of 15 months, but you completed it in 3 months by virtue of a presidential act. So that's the proposition there. Now, we go back to what the argument is about, which is the argument we are dealing with today. What, and the point I was trying to make to Justice Mdiba, what does Section 47(1)(e) deal with? It deals with 2 scenarios. Scenario 1 is where we are right now, which is the sentence imposed by the court. And does that mean that Mr. Zuma is precluded? The answer to that is yes.
That will be the sentence that will be reflected in SAP 69.
Precisely.
Okay.
And then it deals with the second scenario, which is that sentence remains, but you have completed it because there has been a presidential remission. You cannot return to prison. It's finished. There was never a sentence of 3 months in this case. There was always a sentence of 15 months. But he completed that sentence because the president, as a fact, released him from prison.
So, in other words, would you accept that the remission does have the legal effect
Yes.
on the sentence that is imposed?
No, on the sentence that is served. That is what I'm arguing.
It has got a legal effect on the sentence that is served, not on the sentence that is imposed.
Yes, that fact never changes. My lord. It never changes at all. It always remains. That was the sentence imposed. And if he finishes that sentence in a period shorter than the actual sentence because of the remission, then he would qualify under the last sentence of section 47(1)(e).
So the sentence that we look at for the purposes of the last sentence in section 47(1)(e) is the 3-month sentence. Because that's a sentence that he completed. There's no other sentence that he completed.
No, my lord. The sentence is always 15 months because that was the sentence.
But for the purposes of the last sentence, because the last sentence determines the period of disqualification, the disqualification ends 5 years after the sentence has been completed. There can't be 2 sentences.
No, there's always, exactly my point, there's always one sentence. It's
Yes.
always 15 months. The 15 months could be completed because you've served it, but it could also be completed because there has been an executive act that reduces that sentence. The sentence is still 15 months, but you've completed that sentence because you've received a presidential pardon or you've received a presidential remission. But the legal fact remains you were convicted and sentenced to 15 months. That never changes. What may change is when we calculate, when did you complete this for the second part of section 47(1)(e).
Yes.
We would then say, well, you completed it earlier than the 15 months because you received a remission. And that is the point I was trying to make with Justice Modiba when I tried to say, he will benefit from the remission, but that benefit will be 5 years from the time that he received that remission, because the effect of that remission was a completion of the sentence. The effect of the remission was never to change the sentence imposed.
I'd like to hear your response to the submission by Mr. He took us through several synonyms of the word remit, right? And the ones that remain in my mind is set aside, cancelled, and you have emphasized now in your submission the one synonym, reduced. Now, I'd like you to address me on the other synonyms, because if remit means set aside, and you'll recall the debate I had with him, whether his argument is that effectively the remission of Mr. Zuma's sentence by the president interfered with the sentence that was imposed by the Constitutional Court. And that would be so if the synonym set aside is the one that best describes what the president did, or cancelled best describes what the president did.
What we say that the leadership does not have to look at the dictionary for this, because there are judgments that deal with this. And Mr. Bofo has relied on the judgment of Smith, and the one I'm looking for is Smith, actually, at page 47, particularly paragraph 34, page 58 of their bundle of authorities. So if you look there, it doesn't use the word reduce, but it uses the word deduct. And so, which is closer to reduce. And so that's why I say to the court, so if you look at paragraph 34, page 58, it's a judgment, I think, of Straight on J. Yes.
Yeah.
So out of those synonyms, the closest juridically is deduct or reduce, but not set aside. He has no power to set aside anything. He has the power to forgive, which has the consequence that the period that a prisoner spends in prison is reduced or deducted.
No, but what is being reduced? Because his powers as set out in section 84, is it section 84, 1J of the Constitution, to remit a sentence. So if you are saying when he remits, he deducts from a sentence, what does that mean?
Well, what it means, it's, in fact, if you look at the actual, it's interesting when you look at the proclamation itself.
Which proclamation?
The proclamation in this case. It's interesting that it actually never refers to the sentences effectively disappearing or evaporating. I just want to find...
Please refer me to the document.
Yes.
You've given us bundles.
That's 167
Of the pleadings bundle.
of the pleadings bundle.
167.
It's not the Afrikaans version.
So 167.
Sorry, man, just 167, yes.
It's 167.
So what is interesting is that he actually never says the sentence changes from the sentence originally imposed. And what this is about really is regulating the remaining period of incarceration. So if you look at paragraph 1, 2, 3, 4, there's no 5, but 4, 6, 7, and 8. So even when you look at the text of the actual instrument of the remission, it never supports what is contended for today. It simply is about the remaining part of the incarceration.
So you are saying the sentence imposed by the court remains? The remission only affects the period served?
The
Period served in prison.
The period of the incarceration, that's the power of the president. So for purposes of section 47(1)(e), it's always the sentence that was imposed by the court that it should be taken into consideration. Because that's the correct sentence from a purposive perspective. Because that's what tells us what the court thought about the conduct of a particular individual. Your Lordship presiding, I'm not sure if I did answer your question, but it was a long way towards it. But I think finally at least I've answered it.
Yeah.
Sorry, Mr. Hugo.
There's a question from my brother on the left.
If I may take you to your bundle, page 47, the Freedom Front judgment, page 15. Could you please take me through it? So the paragraph 15, that's on page 54.
Our authorities bundle. What's the specific issue that I should deal with?
Paragraph 15.
Yes, I've heard you, my lord. But what exactly about paragraph 15?
It talks, that paragraph, the interpretation relates into that the period of the sentence should be completed for 47(1)(e) to be completed.
I'm terribly sorry, my lord. I still don't understand exactly what. I've got the section, I've got the paragraph. I just don't understand what the question is.
The question is, if we rely on the interpretation that the sentence for the purposes of 47(1)(e) should be served to full completion. In other words, there should be no interruption
I've never suggested that it should be served to full completion and that will be no interruptions.
No.
I have expressly said that the effect of the Presidential Act, and again, I mean, maybe it's me who didn't explain this properly. I've expressly said the effect of the Presidential Proclamation was never to undo the sentence imposed. What it did is that it rendered that sentence completed by operation of law because it meant that he could be released after 3 months. So, as a fact, it didn't complete it because he didn't serve the 15 months. But the president brought that completion forward because 3 months he released him. But Section 47(1)(e) does not help us there because that section is about the sentence imposed by the courts, unless it has been overturned on appeal. So the issue around paragraph 15, I mean, I read that judgment. That judgment was about the wholly suspended sentence. That's why I thought it's irrelevant to this debate, because this is not a wholly suspended sentence we're dealing with. What Freedom Front Plus was arguing is that even though Mrs. Mandela was given a wholly suspended sentence, he should nevertheless be precluded by virtue of Section 47(1)(e). And this court said no, it shouldn't be, and that the interpretation they were placing on the section was not supported by the text or the purpose of the section. This case stands on a different footing. This case is about a sentence actually imposed without option to fine, which makes it within the confine of Section 47(1)(e). And again, I want to repeat this so that if Professor, you leave this room believing that my submission was that he should be serving the 15 months, that's just wrong. My submission was there are two ways of looking at completion. One way of looking at completion is to complete the entire sentence. Another way of looking at completion, which I submit the court should endorse, is that the sentence remains, but the completion period, which is the period of service, is reduced because of the interference of the presidential remission. And that is why Mr. Zuma will in fact benefit from the last section of Section 47(1)(e) within 5 years after the period of completion. And that period of completion will then be the period when the president released him from incarceration. And that still doesn't answer the primary issue before this court, which is what is the sentence imposed.
Thank you, Mr.
So you're saying because he said if he completed the sentence earlier by virtue of the remission, then the 5-year period will arrive earlier.
It will arrive earlier. That's the benefit of the 5-year period, because the completion is the actual release, it's the actual service. But he is prohibited. So the point I was trying to make is, I'm not suggesting that that remission will never bear any benefit to him. It will. He will get that a lot earlier than he otherwise would have.
Question? One question? Right, thank you, Mr. Ngoitobi. Thank you very much. You wanted to be excused.
Yes, I still want to be excused, although I'm not sure how long of the remaining interview I'll still catch. I just need 2 minutes to sort myself out.
Sure.
Mr. Mitchell will address the issues around
Bias.
choosing bias indeed.
I gave Ms. May 15 minutes to address us on bias. I think that it would only be fair to give you the same period.
My Lord, I will be within the 15 minutes.
Okay, so it starts now.
Thank you, my Lord. My Lord, I first want to deal briefly with the test for bias, and then I want to meet the allegations that we made against the Electoral Commission. And just for your note-taking, this is dealt with from paragraph 31 onwards from in the Electoral Commission's written submission. On the law, the guiding test is SAFU. That's item 12 in our authorities bundle. I don't need the bench to go there. That's simply for your note taking. The relevant paragraph is on page 171 of that bundle. And there the test is put quite plainly that it is whether a reasonable, objective and informed person would, on the correct facts, reasonably apprehend that the judge has or will not bring an impartial mind to bear. And recently in Masuku, that's a case that's not in the authorities bundle but is cited in our heads of argument. The citation is 2022, volume 4.
What's the case, the name of the case?
The South African Human Rights Commission versus Masuku.
Oh, I see, okay.
2022, volume 4 of the South African Law Reports, page 1. And the relevant paragraph is paragraph 64.
And sorry, Mr. Mitchell, in SAFU, what paragraph were you referring to? You only gave us a page.
The SAFU paragraph is paragraph 48. The relevant portion of Masuku, the Constitutional Court, adds that the application of the test requires both that the apprehension of bias be that of a reasonable person in the position of the litigant, and that it be based on reasonable grounds. So it's a double reasonableness test. And the onus is on the applicant alleging bias. So with that test in mind, I want to then move on to meet the allegations head on. And the applicants rely on two sources of the reasonable apprehension of bias. First is the quote itself from Ms. Love, and the quote is on page 225 of the paginated pleadings. And the Electoral Commission's response is a simple one. It is that Ms. Love was responding to a question stating the law and the correct legal position, that if there were to be an exclusion, it would be the law that would be doing the exclusion, not the Electoral Commission. And that, with respect, is the answer, Justice Modiba, to the question that you put to my learned friend about whether this is a statement of law or a statement of fact. And we say it's a statement of law plus a hypothetical, to say this is the law. If there is an exclusion, the person doing the exclusion is not the Electoral Commission in the sense of the people who are on the commission. It is the law that's doing the exclusion. And that's how we submit a reasonable observer would read that statement. And particularly the phrase, it is not ourselves. The statement is not, Mr. Zuma is not eligible to stand for elections. The statement is, if there is an exclusion, paraphrasing the statement, it is not ourselves doing the excluding in the sense that it's not Ms. Love or the CEO or the chairperson of the Electoral Commission. It is the law that's doing the exclusion.
But do we know what the question was?
The question itself is not on the papers, no. My lord.
We were taken to the Commission's answer to this allegation. There's a specific paragraph. Please remind me.
Yes, that's from paragraph 17 onwards on page 235 of the paginated papers. And paragraph 20 on page 236.
So the Commission says, the Commission is trying to help us understand what she meant, right? Ms. Love simply stated the correct legal position. Moreover, her statement was made in response to a question about Mr. Zuma's eligibility. So they confirmed what the answer related to. Neither Ms. Love nor anyone else from the Electoral Commission raised Mr. Zuma's eligibility on their own accord. From the context of what I had stated above, it is also clear that MK Party has always taken the view that it would compel Mr. Zuma's candidacy, including by threats of violence. So what should we make of that answer?
Two important points to make of that answer. The first is yes, the Electoral Commission says that the question is about Mr. Zuma's eligibility. We don't have the verbatim question though, but it is about Mr. Zuma's eligibility. We've never shied away from that point.
Yeah.
The second point is the important context that's added in the last sentence of that paragraph. That the Electoral Commission, and it's on the papers, is concerned about the threats that have been made. And that's an important contextual point because of what I mentioned a moment ago about the phrase, it is not ourselves in the direct quote.
Sorry, the reference to threats of violence, what does it have to do with your answer?
Yeah.
Because your answer relates to the media statement. So, the threats of violence, what does it have to do with the answer that you wanted to do?
My Lord, because in this paragraph of the answering affidavit, an explanation is made for the answer. Part of that context of the answer is what the Electoral Commission was concerned about. And why that's important...
Sorry, I'm not with you. I'm not with you now. You are pretty fast. The reference to threat of violence, okay. The issue is about the statement here.
Yes, my Lord.
Now, then there's, in your answer, you refer to the threats of violence. What's the relevance of the threats of violence to the answer that you were providing?
The relevance
So what?
The relevance is because it adds context to the statement that is made by Ms. Love.
The statement being what?
The statement that's quoted about that paragraph.
Which says what? Just
That says that starting with that excludes anybody and ends with impediment for that candidacy. And the
but
particular
still, I can't see the connection between the two.
The connection is the way this statement is phrased, and particularly the phrase, it is not ourselves. What Ms. Love is saying, the point of Ms. Love's statement, and we know that because of that phrase, is that if there is an exclusion, it is not us personally who are doing that excluding. That is
The function of the law.
That statement is made in the context of the Electoral Commission members being concerned about marches to the Electoral Commission's offices and threats of violence. Ms. Love is saying, if there is an exclusion, the law is doing the exclusion, it is not Ms. Love, me personally. And that is the context that's given in paragraph 20.
So are you saying, are you saying Ms. Love was not determining whether Mr. Zuma is legible?
She was
Ms.
not.
Love was stating a hypothetical case. Says, in the event that he is disqualified for standing for a position, it's not because the IEC said he is not, it would be because the law says so. Is that?
Precisely, my lady. And we know that also because, and we've heard a lot about the debate this morning about dictionary definitions and grammar. The key word that is used in that last sentence of the quote is would stand. Would. The word is not will, the word is would. And would means a hypothetical. It's not saying Mr. Zuma is ineligible or that Mr. Zuma will be ineligible. It's saying he would be. Or not even saying he would be, it's saying if there is an exclusion, that would be the work of the law doing it, not the Electoral Commission as an amendment.
Yeah, and would you say the fact that she says that excludes anybody and that she didn't specifically mention Mr. Zuma in her answer stated the law and she was not applying the law to Mr. Zuma's case?
Precisely, my lady. And added to that, the other two important points of context that you raised in the debate with my learned friend about the timing, that this is happening in January, and secondly, that when this is happening, there aren't even any complaints before anyone. The objection process isn't even open yet. We're far down the line there. And reading all those contextual points together, our submission is that the quote itself does not give rise to a reasonable apprehension on reasonable grounds.
Can I follow up?
Yes.
Mr. Mashida?
Sure, go ahead.
Okay, thank you very much. Earlier on, we heard that the Commission has prejudged this matter because of the statement which you allege that Ms. Love was just stating the legal position. But from this paragraph, the second sentence before the last one, that it is your submission that having considered the context, the Commission is of the view that the MK party had always intended to bulldoze Mr. Zuma's candidacy into the list, wherein this last segment of the sentence comes in, that including threats of violence. So if the Commission had always been of this considered opinion that the MK party had always wished to bulldoze, then how would you link to what you are stating before this court, that Ms. Janet was just stating the law, but on the other hand, you had always have this opinion that MK wanted or intended because of the scenario. This is your view that you are presenting before this court.
Well, the context that's added to the statement is that there has been threats of violence from a party. Ms. Love's statement simply says if there are going to be objections, if someone is excluded, it's not me personally doing it, it's the law. So there are threats being, or there's certainly noise being made by some political parties. Ms. Love, again, she, as Justin McKeever points out, she's pointing out that if anybody is excluded, given that there has been this noise, if anybody is excluded, don't look at us personally. We are simply applying the law, if it happens in this hypothetical scenario. If there would be an exclusion, it's not ourselves doing it, it's the law that's doing it. It's not specific to the MK party. The fact that the MK party was the noise that was being reported and was perhaps more prevalent than any other noise made by political parties does not mean that there was a prejudging of this particular issue, which was an hypothetical at best at that point in January, before objections had even started. The point being made, and a reasonable observer would, we submit, view it as we are simply applying the law. That is our job as the Electoral Commission. It's not us personally doing this exclusion if there is going to be an exclusion.
So you are saying it so happens that ultimately the hypothesis became real. Yeah?
And that so happens, but that's not a
That's not, she was not prejudging it. It just happened that the hypothesis became real. Because subsequently there was an objection, the IEC considered it, and then it found that he is disqualified. But not because Ms. Love said so, but because it so happened that the hypothesis became real.
Precisely. And it's true that it's not Ms. Love who's been doing the exclusion. It is the Electoral Commission applying the law. Exactly what she said.
So,
Go ahead.
Mr. Mitchell, then would it be correct that it doesn't matter what Ms. Love meant because it was the Commission applying the law? Is that the version? Because it concerns me that all this is said about what Ms. Love said and what she meant. We don't know exactly what she said. There's not even a confirmatory affidavit from Ms. Love, never mind an explanation from herself that I did not pre-decide the issue, and I didn't say that this person is going to be excluded by us.
Milady, we agree it's an objective test, and we don't have Ms. Love explaining what she said. We don't deny that she said those words. Applying an objective test based on a reasonable observer, we would submit the reasonable observer would know that the context, but would also interpret these words and form the impression that all Ms. Love was saying was that the law would be applied.
So, Mr. Mpofu's interpretation of those words is that when we read that candidacy, it refers to Mr. Zuma, and your interpretation is that all it says is that it is not us. So it's a frightened commission trying to protect itself.
There are a few questions in the packet. That candidacy, we say, we're not referring specifically to Mr. Zuma's candidacy. It's referring to the hypothetical of if someone is excluded, their candidacy is excluded by virtue of the law. And the context is important to interpret the words, but the words ultimately carry the day. And we submit that the words simply do not rise to the level of a prejudgment. The other point I'll make was that because the onus is on the applicants, if there is doubt on this interpretation, then the doubt is resolved in the respondent's favour, since we are not the ones who bear the onus for the test for bias. That's the first source of the reasonable apprehension, is the quote itself. I can be briefer with the second source, which is the rest of the article, the headline, the reporting. There's no dispute that the Electoral Commission had nothing to do with the headline and how it was reported, and that allegation is made by the Electoral Commission. That's paragraph 21 of the answering affidavit, and it's not refuted. That means the applicant's argument becomes something like bias by omission, that the Electoral Court did not take active steps to correct the reporting and the headline. And there are two problems with that theory of bias. The first is that that type of bias is not alleged squarely in the grounds of appeal. And it's not even alleged that the Electoral Commission knew about this article at any time. The grounds of appeal deal with this allegation of paragraphs 11 to 14 on pages 16 and 17. And the allegation is not made, for example, that the next day we drew this to your attention and you did nothing about it. And that leads to the second problem, that there is, as far as we are aware, no duty on a decision maker to roam media reports and correct what is said. The allegation must stand or fall on what the words used were, and I've explained to you why we submit. That does not rise to a reasonable apprehension of bias that a reasonable person would hold. Those are our submissions on bias, unless there's anything else I can assist the bench with.
Any question?
Not from me, thank you.
If not, then I'll simply wrap up our case as a whole, and would ask this court to either dismiss the application for leave to appeal, or if leave is granted, to dismiss the appeal itself. Very briefly on costs, we do deal with this in the final paragraph of our written submissions. There does seem to be some conflicting case law from this court about the power of the court to grant costs orders. The Electoral Commission is happy to leave that in the court's discretion. The short point that I would make is that a request for personal costs is made, and we submit that even if this court has that power, the litigation conduct of the Electoral Commission does not come close to the standard that this court has set for personal costs orders. Those are our submissions.
Thank you, Mr. Michel. Yes, Mr. Mpofu, you've had a debate between Mr. Mpofu and the court.
Yes.
What is your response to that?
The court's indulgence just to deal with both.
Okay. In terms of light. Okay, right. We'll proceed, Mr. Mpofu, as long as if you are not going to detain us for any longer period of time.
If the court can just bear with me.
Sure.
My Lord, I think it will be opportune to deal with this issue of Mr. Mitchell's, just to get it out of the way.
The bias issue.
Yes. My Lord, this is what we call a dog's breakfast. They say, Your Lordship asked many times, what has the violence issue got to do with this? No answer. The reason there's no answer, my Lord, goes to the question of the conduct of the IEC and why it should be marketed with punitive costs and to the extent necessary personal costs. It is not the duty of an independent body to come here and change the case as it goes along, all the things that Mr. Ngokaitobi was saying here and Mr. Mitchell now. The reason, my Lord, is if you go to page 233.
Pleadings bundle?
Pleadings bundle, my lady. If you go there, you'll see the reason why Mr. Mitchell is struggling with this. It's because on their own version, when they introduced the so-called violence thing, which is really unfounded, my lady, my lord and my lady, they themselves say, this is false. On 13th March 2024, the MK Party youth leader, Mr. Bongozi Kanyile, announced the official MK Party presidential candidate and explained and so on and on. That's the so-called violent threats of Mr. Kanyile, which are now being visited for some reason on Mr. Zuma. But Mr. Mitchell tells this court, standing here as counsel, that when Ms. Love was talking in January, she was influenced by what Mr. Kanyile was going to say in March. Really? You know, the real issue is that these are gratuitous submissions which are made to tarnish the good name of Mr. Zuma and the MK Party for no reason. That's all. So let's put that aside. Then he tells us that the statement which was made was general statement of the law. Her ladyship points her to their own paragraph 20 of the answer. It's not us. They say the question was about Mr. Zuma. They say themselves.
Please give me the page number again.
20. It's paragraph
That's
20
paragraph. I need the page number.
I'll get the page number just now, my lady. 236. Thank you. So there's a clear admission, which is what Presiding Judge Justice Zondi was saying. We know what the question was about. So when she says that candidacy, she's not talking about theoretically. It's the one that was, if the question was about Mr. Mitchell, then she says, no, there'll be a problem with that candidacy. She can't then say, no, I was talking about the general South Africans. Right? We admit, again, in case the last time I made an admission, I was in trouble. We admit that the first part of that sentence that she says, that excludes anybody who has been given a sentence that was not subject to any deferral. In that sense, this is not ourselves, but the laws of the country, up to ourselves. That first part was obviously a general statement of the law. And that's what Justice Mudiba was asking from my learned friend. Which is which? And her answer correctly was both. Because that first part deals generally. But then once she says, but it is not ourselves, but the laws of that country that would stand as an impediment for that candidacy. If you read that together with paragraph 20, with their admission in paragraph 20 that they were talking specifically about Mr. Zuma, then there's nobody else that she could have been talking about. And here's the submission before I move out from this. Just imagine, honestly, you know sometimes lawyers complicate things that don't need to be complicated. Imagine if I did something, I took my learned friend's book here, and then they say, you stole that book. Mr. Mitchell says, I know him, he's a thief. He stole the book. and called a press conference. I said, I know, he always does that. And so on. Okay. 2 weeks later, Mr. Mitchell has made that statement. Then I'm told I have to face a disciplinary hearing for the theft of the book. And I'm told, who's the chairperson? Mr. Mitchell. The one who said, that if we're going to catch him. I mean, honestly, how can you, that's what the principle nemo, udex, and all those Latin terms are all about. You cannot be a judge in a matter which you have already prejudged. That statement was made by Justice Shaw at JP, and it has been often quoted in our books in Hamata. I'm sorry, I'll find it. Sorry, Justice, I have to. In Hamata versus Chairperson Peninsula Technical Internal Disciplinary Committee, just the example I was making, Shopper JP said, no one can fairly decide a case before him if he has already prejudged it. Simple.
Is that judgment in our bundle?
No, it's certainly not in ours, but it's cited in our heads. I can give the citation.
Give me just the name, if it's cited.
Yes, it's Hamata, H-A-M-A-T-A. H-A-M-A-T-A, Maledi, versus Chairperson Peninsula Technical Internal Disciplinary Committee. It's 2000, Volume 4, SA 621, decision of the Cape Division. But the point is made in Hookster that when the matter went on appeal, that proposition was not disturbed. And it's simple. No, how can you can't? There are two options. Remember, there's also freedom of expression. So she should have done what anyone sitting that side would have done if you asked a question. What do you think about this MK case? You would say, you can't comment on that. You would say that even if before, because it might come before me. So she failed to do that. Okay, let's say we accept that. Once you have failed to do it and you've commented, then you must recuse. You can't have it both ways. You can't fail to do the right thing, which is no comment, and then also sit in judgment. It's not done. It's wrong. One doesn't have to be a lawyer to understand that you cannot do such a thing. Such a decision must be set aside as a nullity. And move on.
The IEC seems to place some weight on the fact that the question they didn't raise it, Meramutu.
My little friend Ms. May answered that question, maybe not as robustly as I would answer it, which is, so what? It doesn't matter whether the question, whether Ms. Love woke up one day and said, I'm calling a press conference just to talk about Zuma, or whether somebody asked the question and she answers it. What difference does it make? That's why I was making this example. If someone said, Judge Mutiba, oh, I'm sorry to make an example of you, or any judge. If someone said, Judge X, what do you think about AKA's murder? And that judge, he says, I think they're guilty, and all that. And then 2 weeks later, we hear that it's that judge who's sitting in the matter. It doesn't matter that he was answering a question. He should not have, that's why I'm saying he should not have answered the question in the first place, but put that aside. But once he has, then he would have to recuse himself. That's all. So the question thing is just a red herring. Anyway, let's move
to the next point. I think that we have answered that point exhaustively.
Yes, the bias point. Let's go to Mr. Nuhaito.
Sorry, Mr. Mhofu. If we find there's merit in the bias point, we still have to determine the main issue, do we not?
No. You can't, the main issue is
but then does the objection get remitted?
No. This is not a review, it's an appeal.
Yeah,
no
so
remission.
We still have to decide. Well, there's still an objection to be decided.
No, there's no objection to the objection has been decided. Your job is now whether to uphold or set aside the decision of the IEC.
But if the decision is a nullity, it hasn't been decided.
Well, if it's a nullity, well, it hasn't been decided, but the time for it, in terms of section 33 and 32, it cannot be decided beyond the 27th of the 28th of March, in terms of the election timetable. So it has been decided. It's not that it's gone with the wind. Now, and I'm glad you asked that question, my lady, because it's important to make that distinction that this is an appeal, not a review. But let's go to Mr. Ngatobe. I'm sorry that he's not here.
Which point are we dealing with now? Section 47 point?
The rest.
Okay, sure.
Section 47 in its multiplicity, my lord, starting with ultra-virus, sentence, conviction, and so on. Mr. Ngatobe, it's a pity that he's not here because he made a comment about something that he calls fundamentally misguided. Well, if you take away the subtle insight, let me tell you what he says is fundamentally misguided. He said, Mr. Ngatobe says, this court is asked a simple question by the presiding judge. What are we to make of section 19 vis-a-vis section 47? And he gives the most incorrect and I don't even know how to describe it, answers. He says, no, you can't do that because it's all in the Constitution. It's fundamentally misguided to try and pit a section of the Constitution against another. Well, it's clear that Mr. Ngatobe has never heard of section 39(2) of the Constitution. That Constitution makes it clear which of the two things must prevail. That's the answer to your question, Justice Sondi. A section in the Bill of Rights cannot be ranked in the same status as a section in the rest of the Constitution. That's Law 101AAA. So to say that, no, you are pitting the two, that's why all these cases have been saying Section 19 is the foundation of our democracy, because it's in the Bill of Rights. So there's something called the hierarchy of laws, and it's here, but I don't have time. The court strikes this proposition. The hierarchy goes like this. It's the Constitution, obviously, legislation, and then it's delegated legislation. But in the Constitution, the hierarchy is that the Bill of Rights, that's why it's called fundamental rights, is the, Mr. Ngatobe talks about Section 36. You can't apply Section 36 to Section 47. Section 36 is only applied to the Bill of Rights, Section 19. So if anyone, I'll tell him tomorrow when I see him, who is fundamentally misguided, it is him. And so you can't, it's not like you are doing, it's not a battle of equals. Section 19 is the be all.
Well, Mr. Mitchell would convey a message to him.
Yes,
for him.
Yes, I'll call him. I'm probably going to see him later. So that's the wrong answer. Then he's asked another question, simple question, for half an hour, I think 40 minutes. I was counting. He's asked a simple question: when did the sentence expire? When was it completed? No, it was never completed. No, it was completed when it was 3 months. And we got like every version you can think of. No, there are two answers. It was that day or this day or whatever. The answer that you are looking for those minutes, Miss, it comes from Dr. Remember, Justice Yakub has just reminded us. After all, we're here because of an appeal to what? Objection. The answer to the question that this court has been grappling with is provided by none other than our Dr. Matsapula, the real person who brought us here. He says in paragraph 6, you'll find that at 247. His objection starts at
247
of the pleading party. His objection starts at 246. So we have the IEC now taking up the fight, fighting a bigger fight, and going to war for this person's objection, and exaggerating the objection by giving us multiple dates of completion. When the real objector gives us the answer, here it is. Mr. Zuma, Mr. J.G. Zuma, paragraph 6. Mr. J.G. Zuma completed his sentence when he was released from prison on 11 August 2024, following a special remission of sentence in terms of 84(2)J of the Constitution for certain categories of certain offenders. Proclamation is in order. That's all Mr. Mukhatib should have said. It would have taken him half a second, not 40 minutes, to say the answer to that, because we are just an independent body. Here's the objector, tells us when the thing was completed. And the objector knows that there's a remission. And, but we are told that all sorts of gymnastics about whether is it reduced. And, well, if it's reduced, the question comes again from...
But sorry.
I'm sorry. Yes.
There might be something that we're missing here.
Yes.
But what about if that statement is a statement of law and it doesn't reflect the correct legal position?
Because,
the statement in the objection.
That statement in paragraph 6, if it's an expression, if it's a statement of law.
No, it's not a statement
then
of
a statement
law.
of fact.
It's a statement of law. It's
about his understanding about how the law applies. It's a statement that embodies legal conclusions.
No, my Lord, I'm
just putting this so that you can deal with it.
No, it's a valid question.
Yes.
There are two answers to it. One is that the one is the one that where I'm saying we do, as I stand here, I don't know when Mr. Mukhatib says the issue was completed. He was asked a straightforward question, and I'm saying the question is here. He could say I don't agree with Dr. Matsapul if he wanted, or whatever. But I'm saying the originator, the person who brought Mr. Mukhatib to this room, is here saying that it was completed on the 11th. That's the first. The second one, the Lordship is quite correct. If Dr. Matsapula said remission doesn't mean anything, of course the court can't be bound by that because that would be a statement of law. But in any event, maybe let's forget about Dr. Matsapula. You can hear it from me. Our version is that the sentence was obviously completed on the 11th of August 2023. There's no other answer.
Mr. Mpofu, I want you to look at, because you are referring now to Mr. Matsapola's objection and what he makes, Dr. Matsapola's objection, I beg your pardon, and what he makes of the sentence imposed and the remission, right, the effect of the remission. You've taken us to paragraph 6. Shouldn't we look at it holistically? Shouldn't look at the objection holistically. Go to 7, paragraph 7. It says, I submit therefore that in terms of section 747(1)(e) of the Constitution, Mr. Zuma is not eligible to vote to be a member of the National Assembly in that he was convicted of an offense and sentenced to more than 12 months imprisonment without the option of a fine. A period of 5 years after the sentence has been completed. So 5 years from 11 August 2024 has not lapsed.
Yes. No, of course, my lady. Because we don't have time, I'm even prepared. The answer is obviously what Justice Zondi was saying. What his conclusions of law are irrelevant. But let's entertain him. Even if he is, that is what is pleading, quote unquote, then that doesn't resolve the question. The question is not that 5 years has lapsed, because on any version, everyone knows 5 years has not lapsed. Whether it was completed after 15 months or whatever, that's not the issue. The issue is what was being addressed in the case of Freedom Front Plus versus Winnie Mandela. That's what the professor was raising, Mr. Ngatobi, which he did not answer. Paragraph 15 of that judgment is very clear. The gist of that judgment is this. Is the point that was being grappled with Mr. Ngatobi. You cannot, if you say in a sentence, one of his versions was that it's still not been completed. And until one of the judges made it clear, then that means he will never be exempted, because he's continuing forever. Forever, amen. Yeah. Now, and this is what the court said, Mtiana J.A. in that matter. For the above reasons, the second respondent is not disqualified from standing as a candidate for the election of 22 April 2009. As she was not sentenced to an effective term of imprisonment capable of being completed within the meaning of Section 47(1)(e). That's the gist of this thing. That's the judgment of Freedom Front Plus versus African National Congress and Winnie Mandela.
Citation?
Inimatic Mandela. It's in their bundle at page. There you go. Thank you. I'm indebted to Alan. Freedom from Plus versus ANC, bold 2009 square bracket, ZAEC 4, 31 March 2009. And this is it number 5? It's judgment number 5 of their panel. Now, that judgment is very short. It's about 3 or 4 pages, but I commend it because it deals extensively with this question of the completion, because that's what purposive and Dumeni asked us to do. Look at the provision as a whole. So I'll leave it there because I don't have time. Then Mr. Ngatobi, I've also, when I do see him, I'm also going to take him to church. Because even the Bible has an answer to this. It says at Luke chapter 3, verses 1 to 3. And he went into all the region around the Jordan, preaching a baptism of repentance for the remission of sins. Yes. Close quote. The remission of sins. Now, according to Mr. Ngatobi, Jesus Christ can remit your sins, but it's not completed.
But Mr.
It will be completed when the judgment comes. The point of the matter is the point that was made by one of the judges, I can't remember, that the synonyms for remission are forgiveness, which is the biblical one, cancellation, extinguishing, set aside, and so on. And if the legal effect, we're not interested of linguistic tricks here. What is the legal effect of a remission? It is clear from Smith's case is to reduce, in that case, a sentence which was 18 years to a sentence of 16 years. Simple, paragraph 66 of Smith.
But what Mr. Toby, Mr. Mpofu's point is that the remission doesn't change the fact that there was conviction in the sentence.
Yes,
because that was imposed
originally
by the court.
Yes.
And the president and executive, it's about separation of powers. And the executive cannot change what the judiciary has done.
No. My Lord, that is totally misguided.
Wow.
I'll tell him again, times 2.
Why?
Because the reason, you know, my Lord, your Lordship must go into the literature about the so-called prerogative. I'm one of the people, by the way, in that debate who is totally against anything called the prerogative. Because the prerogative is the royal prerogative, which comes from our colonial past, that the Queen is the only second to God, and therefore they can do anything. But that's a debate for another day. But the reason why the prerogative is there, my Lord, or is criticized by those who criticize it, including myself, is that the prerogative does exactly what your Lordship is doing. It interferes with a judicial process. That's exactly what it does. That's what is the entire academic debate about it. But those people who defend it say, no, yes, it might do that. It might interfere with the judiciary and, by the way, even the correctional service system. But the president, the person that we have appointed to be above it all, must be given some leeway to do exactly that, to interfere with the judiciary, as long as he's doing it constitutionally. So that it becomes a rule of law thing. So if you accept that, now my side of the debate is lost. So as we sit here, the president possesses power to pardon even the grossest serial killer. And if you say to him, why did you do it? He's going to say 84-2J. You can't question me. And so that's why it's important, when I was trying to do it in chief, to read that sentence together, J. It says pardon, reprieve, remit. Those powers are specially carved for the president and taken away even from the minister, exactly because they ostensibly interfere with the judicial. So you can't have it both ways. You can't say the president can interfere with judicial sentences because of the prerogative, but he can't because he's not a judge. That's just like a secular argument that goes nowhere, because that's exactly the very point of him having that power, is to interfere with judicial decisions in exactly the same way that a court of appeal would, in the sense that the outcome, the impact, remember we're looking for purpose. What is the legal impact of this remission? It is to reduce, to deduct, to cancel a portion of the sentence, and it goes away. That's why Mr. Nkomadogo was constrained in the end when asked the pointed question, okay, this sentence, whichever one we are talking about, when does it expire? He had to say, after all those things, that it expires on the 11th of August. Now, that means we have a situation where we have a sentence that expired on the 11th of August, but after 3 months, but it's a 15-month sentence. What is that? If it's either it was reduced, cancelled, and extinguished, and reduced to what? Which really was the question Justice Kuti was asking. Okay, it's reduced, but to what? It's reduced to a 3-month sentence. And does a 3-month sentence, is it hit by Section 47 1E? No.
Mr. Mpofu, I didn't hear him to admit when I was debating with him that the sentence was reduced. What I heard him say was that an earlier date of release was determined, right? as a result of the proclamation. But the difficulty would then be, and that's why he kept changing. It wasn't clear what he was saying really about when would then the sentence be completed, because he's saying to us we should work with the sentence that was imposed by the court. But section 47 says the disqualification expires 5 years after the sentence is completed, but we know that that sentence was never completed. We know that that sentence was never completed. Then what does that date become? And then he said, no, the date when he was actually released. But we know on that date that sentence was not completed.
Yes. No, my lady, I don't blame you. We got so many answers from Mr. Nikaito. But ultimately, my lady, in his defense, since he's not here, ultimately he considered the point. When your ladyship, remember when your ladyship was telling him about the synonyms?
Yes.
Then he took us to paragraph 34, page 58 of our bundle. And he made the concession, my lady. Maybe your ladyship didn't record it. He said, that paragraph 34 says, it should be noted at this stage that it becomes very important for the applicant to determine from which sentence the 24 months remission should be deducted. And Mr. Nikaito said, he accepted that the synonym for deducted included the one you put to him, which is reduced. He did. I have to defend him. So he made that concession that it's reduced. But the question is that it's reduced to what? That's the question he didn't answer. And because it's unanswerable. Because it was reduced from 15 months to 3 months. And he was not prepared to say that, which is the obvious. Because you can't just somewhere reduce. You reduce to an extent. And the SCA has made this very clear. The Supreme Court of Appeal has said, at the point at which he was unlawfully paroled, that's when the clock stopped. And at that point, he must go back to escort to deal with the remainder of that when the clock stopped. The clock stopped at 3 months. He went dutifully, as a person who respects the rule of law, to go and do the remainder, the 12 months balance. When he got there, he was processed and this 12-month portion of his sentence was extinguished, cancelled, set aside, and that's it, forgiven.
But he said, remember when I was debating with him, he said that he will benefit from the remission, from the disqualification. Sorry. So section 47 says the disqualification expires after 5 years, right? And he said he will benefit from an earlier date because the 5 years will arrive earlier. Remember that point?
Yeah, I remember exactly.
Will arrive earlier.
Yes, no, I heard that. That's complete. That's a misguided.
So he says, effectively, he says, no, he's not benefiting yet.
Yes.
His sentence remains 15 months imprisonment, right?
Yes.
He will benefit from the remission
in 2029.
Yes, because the disqualification will expire earlier by virtue of the remission.
Yes. There are two things that are wrong with that. Mr. Zuma, that question is pregnant with a falsity. That Mr. Zuma is hit by section 47(1)(e). If Mr. Zuma is not hit by 47(1)(e), which is what we're saying because of the 3 months thing, he will not benefit tomorrow, next year, 2029, 25. He doesn't need to benefit because he is not hit by the section. He's like you and me. He's not hit by that section. He's like everyone else here. That's the issue.
So you are saying the effect of the remission applies earlier and not at the disqualification
absolutely.
point?
Yes. If let's put it like this, my lady. let's assume that, that's the example I gave in the morning. If he still had a balance of 3 years, for argument's sake, and then he got the remission, and then he now has 1 more year to go, then he would not have completed his sentence, but he would have benefited from the remission. So you can't have a situation where everyone else in South Africa, I don't know, I think it was 9,000 people, benefited from the remission, but Mr. Zuma's benefit must be delayed by 5 years. It doesn't work like that. He benefited, the mere fact that he walked home to Uganda on that day meant he benefited on the 11th of August. And that benefit covers everything to do with that sentence. It covers Section 47, it covers the fact that, as the leadership correctly put it, he was not on parole where he has to go to the parole officer and so on and so on. He was a free person like myself, like my learned friend,
Yeah, and what troubles me with Mr. Ngugaitobi's preferred interpretation is that he wants this court to hold Mr. Zuma to consequences of a sentence.
Yes.
Right. That effectively does not apply to him.
Absolutely. That's what the
that
problem
worries
is.
me. That worries me, I must say.
As it should, my lady. It worries you correctly, because what Mr. Ngugaitobi's formulation really does, apart from the absurd one of saying the sentence will never be completed, it is that one, and your leadership did put this to him in fairness. If the effect of all of those gymnastics is to disenfranchise the person, what are the...
No, he'll vote. He'll vote, so he's not disenfranchised.
No.
Yeah.
I'm saying in a broader sense.
Yes.
Okay, it's to take away the Section 19 rights, you can put it that way. Whichever
The
one
right to stand for political office.
Yes, which is 19.3b.
Yes.
I'm now talking 19.3b
Yes.
specifically. If the effect is to take away his Section 19.3b rights, then the court should be circumspect to have this mixed masala, and let's put plaster here, let's put band-aid here, and then let's breathe life into it, and then it works. It doesn't work like that. The court should be absolutely convinced that before it can slash the rights of, as I on the version of the MK party, I don't know, millions of people, but as I said, the numbers don't matter. They say that the biggest poll is the one on the 29th of May. So assume it's 10 people who will vote for them. The rights of those 10 people, as citizens of the country, the rights of the party and the rights of Mr. Zuma, that is the issue, my lady. And your leadership is quite correct. The leadership of any person sitting in your leadership's position should be worried when you are being asked to fix the start, wish away the fact that it says appeal. If you appeal the conviction, then it doesn't apply. No, wish that away as if it's not there. But the purpose of that section was always to try and get to what is called the ultimate sentence. It can never be that Mr. Ngugaitobi is correct that we must only look at the original sentence if we use that juxtaposition. There's something called the original sentence and something called the ultimate sentence. Section 47(1) is concerned with the ultimate sentence. That is all. Otherwise, it's true. Of course, Mr. Ngugaitobi is right. I can say that even if someone gets an appeal or a review. I say, yeah, but originally you were sentenced to do, yeah, so what? That doesn't take us anywhere. The original sentence, if the drafters of the commission wanted us to look at the original sentence, my lady, they would have said, anybody who has been convicted of a crime and sentenced to more than 12 months, full stop. Then we would know that once you're sentenced, that's it. But the legislator says, but no one may be regarded as having been sentenced until such time that we know what the ultimate sentence is, I'm paraphrasing. That's what they say. They say that in their wisdom. And then they secondly say, even that will expire after 5 years. Mr. Ngugaitobi wants you to not only to rewrite the Constitution, but to wish away its obvious words that are in here, which words are meant to protect citizens such as Mr. Zuma from any arbitrary disenfranchisement, and I'm using that word in the broad sense.
Sure.
So the next point is section 39.2. Well, I'm sure the court is familiar with it, and I'll also WhatsApp it to Mr. Mokaitu. It says 39.2, when interpreting any legislation, and this has been said to include what we call the rest of the Constitution, and when developing the common law or customary law, every court, like this one, tribunal or forum, must promote the spirit, purport, and objects of the Bill of Rights, not of the Constitution as a whole. So the Bill of Rights is isolated to be the standard by which everything in South Africa must be interpreted. So there's no competition between Section 47 and Section 19.
Yeah.
Or
I just want you to clarify this. So Section 39.2 deals with the interpretation of legislation,
yes,
the development of common law or customary law, right? So Mr. Mukaitobi said we are interpreting two provisions in the Constitution.
correct.
Of course, one is in the Bill of Rights, and that's Section 18. The other one is not.
Yes,
It's not in the Bill of
that's the point
Rights.
I'm making.
And your point is that in that case, the rights in the Bill of Rights still have supremacy.
Higher in the ranking,
Yeah.
in the
Okay,
that's all.
that's your.
So I'm saying what Mr. Mugaitobi says is fundamentally misguided, is actually the most basic law, which is that the Bill of Rights has been elevated, rightfully so. That's why it's called the Bill of Rights. It's the fundamental rights by which we live or die.
But
All these other things can be amended, but the Bill of Rights is the
well,
Bible.
Mr. Mpofu, isn't the answer in the Constitution itself? It's Section 7 of the Constitution, which
Seven
is the
two.
first section of the Bill of Rights. Well, it starts with Section 7.1, which is that it's the cornerstone of democracy in South Africa. Then 7.3, that the rights in the Bill of Rights are subject to the limitations contained or referred to in Section 36 or elsewhere in the bill, not in the Constitution,
Absolutely.
but in the bill.
In the bill.
And the other thing is, of course, that amendment of the Constitution is also tiered.
Absolutely.
And the Bill of Rights and the founding provisions have special protection.
Absolutely.
So the Bill of Rights obviously, in the
Hierarchy.
hierarchy, supersedes the rest of the Constitution,
Absolutely,
other than the
Maledi.
founding provisions.
And to crown it all, Maledi, and that's what, when we talk, that's why I'm saying we have the supremacy of the Constitution, but within that supremacy, the Bill of Rights ranks higher. Couldn't put it better, Maledi. But Section 7.2, Maledi, just to agree with you, makes it plainly clear. It says that the state must respect, protect, promote, and fulfill the rights in the Bill of Rights. So again, the Bill of Rights is isolated from the rest of the Constitution. This is, as I said, Constitutional Law 101. It's really, we shouldn't be
7.3 seems to be relevant as well.
It's also, yes,
It
there was
says
Section 7.
the rights in the Bill of Rights can be limited, but they are subject to the limitations contained in Section 36 or elsewhere in the bill, not elsewhere in the Constitution.
Absolutely. And Mr. Mugaitobi told this court that Section 36 would be applied equally to Section 47 and Section 19, which is shocking, to say the least.
Okay,
So-
but sorry, Mr. Mpofu.
Yes.
Then how do you link your Section 81 to
Section 8.
81 of the Bill of Rights
Yes.
on the application of the Bill of Rights? Because the Bill of Rights applies to all
Horizontal.
bodies,
Yes.
including the executive, the legislature, and the judiciary.
Yes.
Then how do you link the application of the bill
Now, Section 8.
with reference to 47.1?
Yes. Section 8, Professor, is the bill that produces the horizontality. In Section 8, Section 8.1 and 8.2 deal with the application of the Bill of Rights intersect among the persons. including even juristic persons. In other words, the belief that was there earlier, I remember arguing this so many years here in a matter. We all believed during the days of the interim constitution that the constitution only has horizontal application. So this section in the final constitution of 1996 was introduced so that it says the Bill of Rights applies to all law, whether it's called the common law, section 47 or whatever, and binds the legislature, the executive and the judiciary and all organs of state. And then 2, a provision of the Bill of Rights binds a natural or a juristic person, and to that extent it is applicable taking into account the nature of the right. So section 8, you are quite correct, Professor Nkam, is the equalizing section that makes those sections applicable even to the IEC, as it were, because in the olden days of hierarchy, they would say, well, we're not really an open state, we're an independent. It doesn't matter. All law that the Bill of Rights applies. So section 19 is the whip by which the entire issue has to be determined. That is why, as I said in the morning, the opening words of section 47 are taken directly from section 19. It says every citizen has the right to vote if you have the right to vote and so on, and to be eligible for membership. And then it says except. So it literally, if anything, re-imports section 19 into
So you are reminding us that however we interpret section 47, we must remember that Mr. Zuma's right to stand for political office is
constitutionally protected.
Is constitutionally protected.
That's correct, my lady. And that proposition, my lady, was repeated recently in the most recent case on section 19, which is One Movement South Africa NPC versus President of the Republic of South Africa, 2024. 2 is actually last month's law report, the March law report, 2024 bracket 2 SA 148. Paragraph 126 and following, Chief Justice Zondo said the following. As I've said above, this case concerns the right to vote, the right to stand for public office, and the right to free and fair elections. There are at least 3 cases that have come before this court in which this court was called upon to determine whether certain statutory provisions limited or infringed the right to vote. Let me pause there. In other words, whether the Electoral Act can infringe this right. And then he says that it was New National Party, Recta, and the DA case. Let me just jump to yes. As I have already said, this is the next paragraph. I'm jumping the rest of 126. This case is about every adult citizen's right to vote, every citizen's right to free and fair elections, and the right to stand for public office, and if elected, to hold public office. All of these rights are entrenched, which is the discussion we've just had, in section 19 of the Constitution. These rights are very important in our constitutional democracy because they are primary pillars of any democracy. This is because without the right to vote, there can be no democracy. The right to vote means nothing if it is exercised in an election that is not free and fair. The right to vote is meaningless unless it is accompanied by a right to stand for public office. So that's the debate we're having, my lady, when you're saying he still has the right to vote. The Constitutional Court says the right to vote is meaningless without the right to stand for public office. That's what I call the Obama clause. You know, the Americans were priding themselves that the son of a Kenyan immigrant can become our president. It's the same here. all of us, prisoner, hated, loved, should be capable of standing for office. That is what we fought for. Not that only those that we like. Every single person must be. By the way, the August case where we started this morning emphasizes that point, because the August case was talking about people even in a worse position than Mr. Zuma can ever be, even on Mr. Toby's exaggerated standards.
Well, I think that we've exhausted all the points now.
It was just.
Is there any new point that you want to raise?
Yes. No. Yes. Well, my lord. Yes. Let me.
Because I'm just looking at my book here,
yes.
and just to make sure that all the points are covered.
Yes. Thank you. Oh yes. Thank you. Yes. There's a question which came from Justice Yakub, which I did not answer in chief, because I think I was answering another question. It was the issue about Section 47(2). Now, this is another red herring. Section 47(2) does not do what Mr. Mukaitobi says it does. Remember, Mr. Mukaitobi's thesis is that the right to eligibility to be a member is synonymous to the right to stand for elections. Now, Section 47(2) shows that that is not true, because Section 47(2) says, talking about that category, a person who is not eligible to be a member of the National Assembly in terms of subsections 1A and B may be a candidate for the Assembly, subject to any limits or conditions established by national legislation. There are two ways to read that. One is to firstly get rid of the notion that the two things are synonymous, because that section wouldn't make sense. Because it would say, if you are not eligible, but you may stand. So it's clear that they are not synonymous. But here's the bigger point. The bigger point is this. Mr. Mukaitobi says, that's what I was saying, they say in August, in the case of August, that you cannot disenfranchise people by silence. And he says that because 47(2) says this, therefore you must imply that the other subsections, C, D, and E, mean that you can you may not stand as a candidate. That's just wrong.
But doesn't Section 47(2) deal with a total different subject matter? It's about eligibility of those who are set out in Section 47(1) and B. Sorry, 1A and B.
And B, yes.
It's not about disqualification. Disqualification is dealt with in 47.
Thank you. That's the third answer. Yes. But what I'm saying, my lord, even as far as it deals with those people, really that section is for this. You cannot disenfranchise. If I work for the government and then I'm on the national list, or I'm what I call the MP elect, although ostensibly I'm disqualified in 47(1)(e), but I would have to resign before I'm sworn in, something like that. So it's to cater for those situations, so that those people, even though they are still holding the job, they may still be eligible for. But by the way, that section has got nothing to do with the 31A. It's for eligibility to be a member of the legislature.
Sorry, Advocate.
Yes.
That provision has an internal qualification.
Right.
Subject to any limitation.
Absolutely.
And then that limitation, the question that I'm posing is whether the Commission now does not have a competence to screen the candidates that are submitted to contest the elections.
Thank you for asking that question. Because what it does, you see, that's why I'm saying there are many ways of reading that section. It might mean what Mr. Mukaitobi says it means. But it can equally mean that when it comes to the people in C, D, and E, there is no legislation that can disqualify them. So these ones are specified here because they are subject to qualification. So the court is not called upon to choose which interpretation. It could be mine, which comes from what I said about Mr. Nvatovis, except that the court is compelled in those situations to choose that interpretation which protects enfranchisement of Mr. Zuma. Last point, I promise. This is, if you go to paragraph.
So, if I can just, sorry, Mr. Boff, if I can just summarize. If I can just summarize the submission on section 47(1)(e). So, is section 47(1)(e) is capable of having different interpretation, but the interpretation that we should choose is the one that is going to uphold the Bill of Rights.
Yes.
That is section 19 in particular.
Section 19.
That's okay.
Yes.
Sure.
In other words, whenever there's a doubt, if there's a situation, whether it's about the definition of a conviction, remission of sentence, and so on, and there's a borderline, the court is compelled by all the rules we know to err on the side of not disenfranchising millions of people or whatever the number is. And paragraph 33 I want to close with this submission. 33 of August. It says, Parliament cannot by its silence, that's the point I was making, deprive any prisoner of the right to vote. So you can't go to 47(2) and try to find now, and what Professor Ndama was pointing out, see, okay, is there legislation or there's no legislation and so on. And then you say, because of all this, I'm now disenfranchising you. You can't do that. No, in other words, if the drafters wanted to exclude a person in Mr. Zuma's position, they would have just stopped at the word sentence. Then it says, nor can its silence be interpreted to empower or require either the Commission, that was the IEC, or this court to decide which categories of prisoners, that we can say of people, if any, should be deprived of the vote, and which should not, which is what you are being asked to do. Here's the rub. The Commission's duty is to manage the elections, not to determine the electorate. It must decide the how of voting, not the who. Let's go with this. These are our submissions.
Any question? Any question? Okay, thank you very much, ladies and gentlemen, and we should thank you for the manner in which you have argued this matter. It's not an easy matter. It is a matter that involves the interpretation of the Act and the Constitution and the relevant provisions of the Electoral Act. So we need to consider the judgment. So the judgment will be, but we need to, in terms of the timetable. Mr. Mitchell, just remind me, I don't want to make a mistake. In terms of the IEC timetable, where are we? The timetable, I've got it. Let's see, I've got the timetable here.
My Lord, maybe I can assist.
Yes.
Yes.
Deciding appeals were in item 16. Electoral Court must consider and decide an appeal brought under section 34 and notify the parties to the appeal and the Chief Electoral Office of the decision in a prescribed manner by the 9th. Today is the 8th.
That's tomorrow.
So that's tomorrow.
Yes.
You can't expect impossible from us.
No.
Because
it would be,
on Friday we sat until 7 o'clock. So
yes. No, Justice, unfortunately, this is a problem that's created by the timetable, by the IEC.
Yes.
Nobody, what if all the 40 parties had objected or there were objections? There's no way that this court could have just, in 2 days, churned out those. So, in another matter where I'm appearing for a review for another party, we have asked in that matter that the court should give some kind of interim relief. Obviously, it must be fair and it must be debated with the IEC, where it doesn't stop their work, but it also doesn't block outcomes from this court in any of the cases. And that I'm sure between counsel we can find some kind of formulation with the commission, because the fear of parties, not like Mr. Zuma, but of the other parties that have put objections, is that tomorrow will come, the IEC will say, we've printed, we don't care what the court is going to say. So I'm sure that even the IEC wants to avoid that. So I would think that the IEC itself and those of us who have an interest will have to find some formulation and maybe present it to the court as the court is.
No, my lord, I don't have instructions on any of those proposals. The best I can do is ask my client to write to the other side and write to the court if there is a... I don't have instructions on the point.
My lord, it is on the court.
Yes,
it's
binding.
Yes,
Yeah.
on the court it is binding, and that's what's wrong with it. But let's not go there. As matters stand, the Electoral Commission is the only body that can amend that timetable.
Yeah, and
as far as you are concerned, you are bound. You're right, my lord.
yeah, so we are bound by the electoral timetable.
As we sit now.
We have to give a ruling tomorrow, right? It's
Well, that's
impossible
Yes.
to deliver a judgment tomorrow.
Maybe an order.
What we are considering is handing down an order and deferring the reasons. Yeah?
That could be one of the options, but I don't know how that. I don't want to argue another matter in front of you. How that would then affect the other matters where there are appeals or reviews, which also have an impact on the printing of the.
That's not before us.
No, that's not.
We are concerned with complying with the electoral timetable, which is binding on us.
For this matter,
Yes.
I'm just talking about the court in general. I'm saying the court will grapple with that issue, maybe along the lines I was suggesting. But as far as this matter, my lady is concerned, if the court issued the order, then at least to that extent the court would have discharged its duty.
Yeah. I just want to understand what you said has been done in these other matters,
Yes.
which could potentially be hit by the
Okay.
tomorrow's time frame.
Yes, I won't mention the names of the
Yeah.
parties again. There is a matter where Ms. Day and I are acting for another political party,
Yes.
which has been brought in terms of section 21A, which, as a leadership knows from Bloemfontein, is the review section of the. But that matter also concerns the question of the exclusion or not exclusion of people in the ballot box, which is what the timetable is really about. The timetable is about the IEC saying the court must give us this quick decision because we want to start printing
Yes.
the ballot boxes.
Yes.
And all I'm saying is that not in the four corners of this case, I think your leadership's solution is applicable. But I'm saying if you look at the election as such, then those matters would also have to be decided, because otherwise it would mean the work of this court is being undermined. Because what if this court finds on Thursday, for argument's sake, that there was a reviewable error in my other matter, and that those two should
But
be-
those matters are not before us, Mr.
No, I'm
Not before this
answering
court.
the question. I'm just
Yes,
answering
okay,
the
sure.
question about what I was saying about the duty that lies on us as counsel
Yes.
and officers of this court to engage with the IEC in relation to those implications. Justice Modiba has proposed at least for this particular
Yes,
matter,
yes.
a solution that, as I say, would discharge the
Yes.
obligations of this court. But if this court looks at the election itself and whether the IEC, even if you comply tomorrow, will then be in a position to print ballot papers, then
Sure.
that's another.
But those matters are litigated somewhere else, not in the electoral court.
Yes, we got directions from this court on Thursday to say that on.
Okay, the remaining matter, okay.
Yes,
Okay, I see.
But
Those that
if I
came
may,
after
just
us.
simply, my instruction is that the electoral timetable is a statutory instrument. Justice Modiba is quite correct. Paragraph 16 of the timetable that's published in the Gazette requires with respect to this court to make the decision. So it seems then that the only solution would be, Justice Bodiga, with respect to your proposal.
Is to grant an order, reasons to follow.
Let's go.
What time tomorrow? 10 o'clock. Sorry?
Maybe 2 o'clock. As long as it's tomorrow, anytime.
Yeah, maybe we'll send it electronically, you know. If you said 2 o'clock, Mr. Mpofu.
Yes. My Lord, of course, if it's sent electronically...
But you don't have to be here,
Yes.
Mr. Mpofu. You can be excused. You've
No,
got
no,
juniors.
I'm naturally excused, but I'm trying to excuse my juniors as well. If
Oh, I
it's
see.
sent electronically, then
That's fine.
nobody has
That's
to
fair enough.
drive to...
Yes.
That's even better.
Okay, let's send it
Electronically.
As God wills.
Okay. Thank you. The court adjourns.